The question is, should I challenge a USCIS denial decision with the Administrative Appeals Office, or should I just go straight to federal court? The answer is, it depends. But my advice to you, you should go straight to federal court, because the AAO, the Administrative Appeals Office, well, it takes them, first of all, time. Just from the time perspective, just go straight to federal court, okay? In this video, we are going to debate as to why you should go straight to federal court. My name is Bijoux Ngwanda. I'm an immigration lawyer based here in DC. I do work with individuals across the country and around the world because we're dealing with complex, really complex U.S. immigration law cases. If you're new to my channel, you go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like. Don't forget to comment below. Also, don't forget to join us on our private Facebook group where we try to answer questions live. Okay, let's get right into the topic. Should I just go straight to federal court, or should I go to the Administrative Appeals Office, AAO? Well, when you go to the AAO, first of all, it takes time, right, for them to actually give you a decision. And you have already wasted time for them to give you a decision. And most of the time, the decision will be negative because they are going to maintain the same decision that you got at the USCIS office, okay? And this time around, they're coming with a decision that has a lot of explanation to it, a more detailed reasoning. And that's going to be, again, challenging for you at that point to go to federal court to challenge the original decision. And guess what? You cannot bring new facts when you go to federal court at that point, because you have to they're just going to look at the record, right? What's in the record, okay? So that's the reason why you just want to go straight to federal court, sorry. Well, the second reason is that in federal courts, challenging a USCIS decision, the standard is pretty much simple. What is the standard? The standard is whether the decision in question, right, was arbitrary or capricious. Arbitrary and capricious, which is a lower standard for a judge to actually work with, okay? So that's why we want you to go straight to federal court instead of wasting your time with AAO. And then federal court, the way it works is that you file your complaint within 60 days, the government has to respond. And sometimes they'll ask for another additional 30 days. At that point, it's 90 days. They have to respond. At least you have a time line to work with, right? And then not to mention, if they dismiss the case without prejudice, then you know the reason why they dismiss the case without prejudice. Then you can file again. So it's, in other words, you have like two chances at once, right? If you file in federal court and they dismiss your case, well, again, you can, especially if they dismiss your case without prejudice, you can refile. But this time around, you know the reason why the case was dismissed, and you have a better strategy to go with, okay? And you have a timeline to work with. Like, you know exactly within what time frame you're going to get your decision. I mean, the case will, like, at least a response, right? But when you go to AAO, first of all, you're just playing with, you're guessing, right? With backlog is there too, while you don't know when they're going to respond. And most importantly, when they respond to you, if the response is still negative. In other words, if they're still maintaining a USCIS decision, then, well, you just wasted your time. And this time around, they have a more detailed reasoning as to why they denied that benefit. Now it's harder to challenge them in federal court. So choose your fight, okay? So In other words, choose your fights, choose your agency. Do you want to go with AAO? Do you want to go with federal court? It's your choice to make, but we are here to just guide you, okay? If you need a consultation with me on that specific topic and you want to see whether you can go to federal court directly or you can just file an appeal with AAO, or you have an option to just really basically start over, we can tell you too, right? Because sometimes starting over is the best option. So remember, I have a case where we just started over. I-130 petition. We got it approved within 1.5 years. But guess what? The appeal that was sent at AAO, I believe it went straight to BIA. Since 2018, never came back. So it's still pending there, but we already have an approved petition here. So sometimes starting over could be another option too. Well, it's just case by case basics, okay? We work with complex U.S. immigration law cases. That's why we require that you consult with us prior to us handling your case. At that point, we will know which path to follow. Until next time, bye-bye.